got the ticket. You know, we've seen you only a few times over the course of 6 years. This is the first time we've seen you in 2026. The last time you were seen was in December of 2022. I have to look at the order because you failed to appear on January 3rd. She ordered no PR. At this point, she's also saying no PR. She's giving me some discretion as to the amount of the bond. There certainly is no remand, and that's probably more likely the fact that it is a traffic matter. But you got to make your court date. So I am going to set this. She said a 500 cash. What I'm going to do is reduce that to a 250 cash surety. So that is your bond. You got to make sure that you show up, sir. Do you understand that?
Yes, but is it possible, because I've been locked up since 4 days and I don't have no way of, on my phone, okay. Everything is out in it. It's on the outside.
You can't change it. That is the decision here. But let's go over this other matter here. This is, Mr. Hooper, this is a matter of collections in file 15-01121FY. This is a motion affidavit and bench warrant on an attempt police officer assault charge from an offense date of March 12th of 2015. Again, that's over 10 years ago. You failed to appear for an arraignment on April 27th. That date came up again because of the bond that was given to you by the jail. So the underlying reason for the bench warrant was because you had failed to appear for the collections department back in December of 2022. So not much that I can do on this, except really you have to report to collections once you get released. The collections is pretty simple. It's right up on the 6th floor. And you will go to the window there and explain to the clerk, you did make some payments for a while. Looks like the last payment we got was in 2019. But they're also going to be able to look at your income, your expenses, sir, and determine an appropriate amount to pay. Do you understand that?
Yeah.
Okay. All right. Then you are all set, sir. That concludes your arraignments.
I have to come up with 250 to get out.
Talk to the detention. They'll tell you exactly what you need to do.
Okay, so I know we don't have paperwork for Davis yet, so we've got the tablet set up. I can go get Mr. Corrigan started if you'd like.
Sure.
Okay.
Susie's emailing us saying that Judge Simmons signed the complaint warrant for Davis.
I did see that. So
you mean respond to her?
Yes. Yes. Yeah, we'll arraign him. And it says here that you've talked to him. Is that right? Oh, you're muted. I can't hear you.
Sorry. No, that's not accurate. Just because I was told that it was unadvisable for him to come out of his cell.
Gotcha.
Yeah.
Makes sense. Okay. All right. Good afternoon. Mr. Corrigan, I am Magistrate Milmore, and you are Tab Skylar Corrigan. Is that right?
She's not going to if unless you talk down here.
Yeah, I can hear you much better if you talk through that open window. Is that your name?
He's asking if you're a fair judge, Your Honor.
Absolutely. I've been doing this for 20 some years. I wouldn't be here if I didn't like my job. I can tell that you're saying something, but I can't really hear you. So let me do this. Mr. Corrigan, you get to talk with an attorney because those are your rights. So Mr. Hardy here is going to talk with you and provide you some rights and give you
I am
some.
my own attorney. I can speak for myself.
Okay, so you don't want to talk with Mr. Hardy today? He's here to help you. Are you
This is where things take a sharp and dangerous turn for the defendant. In a courtroom setting, especially during an arraignment, respect and composure aren't just expected. They directly influence how the judge perceives you. What we're seeing here is a complete breakdown of courtroom decorum. Instead of using this moment to secure legal help, he's attacking the very system designed to protect his rights. Refusing counsel is already a risky move, but combining that with aggressive accusations and insults, that's a fast track to losing credibility in front of the court. Judges often give some leeway, but there's a limit, and we may be watching it get crossed in real time. The bigger question is, does he actually understand the seriousness of the charge, or is he underestimating the consequences completely?
sure that you don't want to talk to him?
The lawyer rapist with 3 kids?
I
I'm
don't
sorry,
think he
what was
wants
that?
to talk to the attorney, Your Honor.
Okay, well, Mr. Hardy, is there anything you'd like to say to Mr. Corrigan?
Mr. Corrigan, myself and our office are here to help you. I'd be happy to talk with you. I do believe that having an attorney can only be a good thing for you, sir.
On a retail fraud, something so simple a child could win? What is your intelligence level? Where did you graduate?
Well, let me tell you first of all, before he responds, this is a retail fraud second degree. So the maximum penalty on that, sir, is up to 1 year in jail. So if you want to talk to him, he can explain that to you much better than what I can.
So the way I see it is I spent 1 year in jail for $143.58 worth of retail fraud that was taken from me, right? Why do I need a lawyer for that? How simple is that? A fucking retard could understand that shit.
Okay. All right, watch your language, please, sir. Okay, I'm going to step out, give you an opportunity to talk with him, and you can come back and let me know how it went. Okay, here's everybody's join. Okay, all right, so there we go. All right, so Mr. Corrigan, you had a chance to speak with Mr. Hardy. Are you ready to go forward?
What kangaroo court, man? What kind of lawyer doesn't understand kangaroo court?
Sir, that's not why we're here today.
Not a good lawyer. I want to accept.
That's not why we're here today.
I believe he did not express any interest in wanting an attorney, Your Honor.
Okay.
I asked several times.
right. Okay, well, if you can mute yourself and if you'd like, but just don't leave the meeting, okay? Because we at least have one more person. Okay, Mr.
No problem.
Corrigan, if you don't want an attorney and you want to represent yourself, that is your right. So let's go ahead and get you arraigned so that you are aware of the charge and the maximum penalty. So again, your first name is Tab Skylar Corrigan, is that right?
If I make it 40,000.
Sir, she asked you a question.
Sir, we got to get through this so that we can determine whether or not you can be released. The more that you participate, the easier it's going to be for me to decide what is an appropriate bond. If you don't wish to participate, that makes it much more difficult for me to establish bond.
Hold on, isn't this my second offense? That would put me at 60 days, not a year.
No, it's a year. Let me tell you what the charge is. This is file 26-01180SM. This is a complaint, sir, in people. Sir, the people of the state of Michigan, all right, you know what? I can let you sit overnight if you'd like to do that and have somebody else see you tomorrow.
I'll have you fired by then. I'm calling my positions in government.
Sir, all we need you to do is hear her out on
Can I get my fucking phone call?
No, sir.
Yes, the fuck I did. You can't give me a goddamn
Okay.
right?
Not one.
Okay,
Can't give up!
Mr. Corrigan, this is gonna have to wait till tomorrow, okay? So,
Okay, when I get my phone call, we'll see.
Okay, we will check with the paperwork on Mr. Davis and then I'll get him in the arraignment room once we have it signed.
okay, thank you.
Thank you.
Bye-bye.
And just like that, the situation spirals beyond recovery. For today at least, the judge had multiple opportunities to move this process forward, even showing patience despite repeated disruptions. But courtroom proceedings rely heavily on cooperation, and without it, everything comes to a halt. By refusing to engage properly and continuing with hostile behavior, the defendant has essentially delayed his own case. This isn't just about attitude. It directly impacts bond decisions, timelines, and ultimately outcomes. From a legal standpoint, this is a textbook example of how self-representation can go wrong when emotion overrides strategy. Now, stepping back, what we've seen here is a clear contrast between two defendants, one who complied and moved forward, and another who resisted the process entirely. The judge followed procedure, explained rights, and even offered opportunities, but those chances weren't taken. Cases like this highlight how critical it is to understand courtroom dynamics and use your rights wisely. If you found this case as intense as it unfolded here, make sure to hit that like button. Share your thoughts in the comments, especially on whether this could have gone differently. And don't forget to subscribe for more real, unfiltered courtroom breakdowns.